I want you to visualize a very specific scenario. It is 11:30 at night.
Hmm.
You're lying in bed, and the lights are completely off.
And you're probably just totally exhausted.
Oh, completely. You are drained physically and mentally.
Mhm.
And you tell yourself, I mean, we all do this, right? You say, I'm just going to check my phone for 5 minutes.
Just a quick scroll to wind down.
Exactly. You think, I'm going to look at, 3 posts, maybe check 1 text message, and then I'm going to sleep. So you open the app, the screen lights up your face, and the next time you actually look up from that glowing rectangle, the whole room just feels different.
Yeah, your eyes are dry.
Right? Your thumb literally hurts.
Yeah.
And you glance at the time to the very top of the screen, and it is 1:15 a.m. Like almost 2 entire hours have completely evaporated.
And in that exact moment, the immediate physiological response is just, it's this drop in your stomach. It's guilt. It's this really profound sense of personal failure, honestly, where you think, what is wrong with my self-control?
Exactly. You blame yourself. But what if I told you that your lack of willpower had absolutely nothing to do with it?
Which is a wild thought.
It is. But what if that missing hour wasn't a personal failure at all, but like the flawless execution of a multi-billion-dollar engineering architecture that is operating exactly as its designers intended?
Working exactly to spec.
Precisely. Because over the last few weeks, I have been just completely drowning in this massive stack of materials we gathered for today's deep dive. I mean, I'm talking thousands of pages of documents.
It's quite the reading list.
It's unbelievable. We have unsealed internal corporate communications from Meta and Google. We have state and federal court filings from the multi-district litigation over in Oakland.
Not to mention the deep dive legal analyses from firms like AVA Law Group and the Spencer Law Firm.
Right, and a literal medical advisory from the U.S. Surgeon General. And poring over all of this, the narrative that emerges is just staggering.
It really paints a very clear picture.
It does. The tech industry is currently facing what looks like an existential legal reckoning over social media addiction, over youth mental health, and honestly, over the foundational design of the internet itself.
And we are not just talking about this in some abstract, theoretical way, because tomorrow morning, August 18th, 2026, opening arguments actually begin in federal court in California.
Right, for one of the most consequential mass tort trials in American history.
Exactly. You have this massive, unprecedented coalition of attorneys general, school districts, and private citizens, and they are bringing the fight directly to Meta, TikTok, Google, and Snap.
All the heavy hitters.
All of them. And the reason this matters to you, the listener, whether you have a teenager in your house or not, is because this trial is fundamentally challenging the core mechanic of the modern internet.
It's putting the algorithm on trial.
Right. It's asking a judge and a jury to decide if the engagement-driven algorithm is, from a purely legal standpoint, a defective and harmful product.
Which is a total redefinition of how we view our screens. But I think to really understand the legal war that's kicking off tomorrow, we have to understand the ground zero of this entire thing.
The catalyst.
Yeah. Why now? Why 2026? And it really all traces back to the sheer scale of the public health crisis. The medical community basically finally drew a line in the sand.
They absolutely did. And the turning point was arguably back in June 2025.
With the Surgeon General.
Yes, U.S. Surgeon General Dr. Vivek Murthy. He published this incredibly blunt op-ed in the New York Times. And this wasn't a gentle recommendation or, a mild warning.
He went all the way.
He did. He explicitly called for tobacco-style warning labels on social media platforms. He looked at the data and just concluded that we are in the middle of a youth mental health emergency, and it's directly tethered to these digital platforms.
Which is a huge statement from the highest medical office in the country.
Absolutely. And he made a point that really resonates with your opening scenario. He essentially said, we cannot keep blaming parents and kids for failing to self-regulate against supercomputers.
Right, because a matchup is completely unfair. And the numbers in his advisory, which are backed up by all that research from the George Washington University School of Medicine we read, they're just chilling.
They're staggering.
We're looking at a reality where 95% of youth, specifically between the ages of 13 and 17, are on social media.
Basically everyone.
Basically everyone.
Yeah.
And over a third of them report being on it, quote, almost constantly.
Almost constantly.
Yeah. But the metric that really stopped me in my tracks was the threshold for psychological harm. Adolescents who spend more than 3 hours a day on these platforms face double the risk of experiencing severe clinical depression and anxiety.
Double the risk. That's not a marginal increase.
No, it's double. And on the flip side, the clinical trials show that if you take that exact same demographic and you just restrict their usage to under 30 minutes a day, their depressive symptoms plummet.
The causal link is just right there in the data.
It's glaring. But I think we need to look at how that causal link actually functions, like biologically.
Right, because the medical advisory, which is supplemented by all these addiction specialists, it points out that we are seeing fundamental alterations in brain structure during a highly critical developmental window.
The teenage years.
Exactly. The
Right.
adolescent prefrontal cortex, which is the part of the brain responsible for impulse control, risk assessment, all that stuff, it's still forming.
Right, it's under construction.
Yes.
Yes.
And these platforms are bombarding the brain's reward pathways with dopamine in a way that very closely mirrors the neural patterns of pathological gambling.
Wow.
You are seeing identical clinical markers. We're talking severe sleep disruption, attention deficit, and literal withdrawal symptoms when the device is taken away.
Okay, but I want to stop here and really unpack this comparison for a second, because this is where things get really thorny, right?
Yeah.
The Surgeon General is asking for warning labels, but tobacco gets warning labels because tobacco has zero redeeming physiological value.
Right, a cigarette just gives you cancer.
Exactly. But social media isn't tobacco. Even in the reports we reviewed, like that Urgent Matters briefing, there is a clear acknowledgement that these platforms actually provide crucial community building.
Especially for marginalized youth.
Yes. If you are a queer teenager in a highly conservative, maybe geographically isolated rural town, finding a supportive community on TikTok or Instagram can literally be life-saving.
It's a lifeline.
Right. So considering that, is it entirely fair or even accurate to compare a social media feed to a pack of Marlboros? Or is the whole warning label thing just like a very savvy, highly aggressive political strategy to force regulation?
It is a phenomenal question, and frankly, it is the exact tension that the tech companies use constantly in their defense.
I bet.
But the medical experts and the plaintiffs' lawyers, they aren't arguing that human connection is toxic. The distinction is really crucial here. It is not the concept of sharing a photo or finding a community that's the problem. It is the dosage and the delivery system.
The delivery system.
Yes. Think about water. Water is essential for human life, right?
Of course.
But if you forcefully pump 50 gallons of it into someone's lungs, they drown. The mechanism of delivery matters.
Oh, that's a brilliant way to put it.
The argument being made in court is that the algorithms, the underlying machinery designed to maximize engagement at the expense of literally everything else, have turned connection into a hazard.
Because it's too much, too fast.
Right. The clinical data shows this specific delivery system is what's driving the epidemic of cyberbullying, sleep deprivation, and really profound body dissatisfaction.
Especially among teenage girls.
Especially teenage girls, because they are constantly served algorithmic comparisons to completely impossible standards. The community aspect is the bait, but the engagement machinery is the hook.
That makes total sense.
Yeah.
The danger's in the engineering, not the underlying human desire to connect with people.
Exactly.
But, that brings up an enormous legal contradiction. If the engineering is causing a demonstrable, clinically proven public health crisis, why are we only seeing these massive lawsuits now?
Right. Why didn't this happen earlier?
Exactly. Why wasn't Mark Zuckerberg sued into oblivion a decade ago when this data first started looking grim?
Well, because for the last 30 years, the entire tech industry has operated behind, honestly, the most impenetrable legal shield ever written.
Section 230.
Section 230 of the Communications Decency Act of 1996.
Right. The 26 words that essentially created the internet. And I know our listeners are generally familiar with Section 230. It's the basic idea that you can't sue Twitter if a user tweets something defamatory.
Because Twitter is the neutral host, they're not the publisher.
Exactly. They just provide the platform.
Right. So for decades, anytime a plaintiff tried to sue a tech company for the harmful effects of a platform, the company would just throw up the Section 230 shield.
They'd say, hey, don't look at us.
Exactly. They would say, look, we just built the digital town square. We are not responsible for the bad things people say or do inside of it. And the courts universally agreed with them.
Cases were just thrown out constantly.
Over and over again, usually right at the motion to dismiss phase.
But looking through the filings from the Maryland Attorney General's Coalition, which is this huge bipartisan group of 42 state AGs, you see this brilliant, almost devastating pivot in their legal strategy.
It's incredibly clever.
It really is. They realized they were never, ever going to win, by attacking the content. So they just stopped looking at the posts entirely, and they started looking at the code.
Bypassing the shield altogether.
Right. They bypass Section 230 by introducing a design defect argument. They are treating social media as not as a publisher of speech, but as a physical manufactured product that is inherently dangerous by design.
Which is a monumental shift in jurisprudence. I mean, product liability law was built for tangible objects.
Like cars or appliances.
Exactly. If a car manufacturer designs a gas tank that explodes when it gets rear-ended, like the infamous Ford Pinto case, you don't sue the driver who rear-ended you.
No, you sue Ford for designing a defective product.
Right. And the plaintiffs in these social media cases are arguing that the apps themselves are the exploding gas tanks.
Oh.
They are arguing that the features are not neutral tools. They are deliberate, manipulative design choices engineered specifically to bypass rational thought.
You know, Mark Lanier, who is one of the prominent plaintiffs' attorneys here, he has this great phrase. He calls the smartphone a, quote, pocket-sized casino.
That is so accurate.
And when you actually break down the specific features that the lawsuits are targeting, the comparison isn't even a metaphor anymore. It is a literal description of the behavioral psychology at play.
Absolutely.
The plaintiffs have actually isolated 7 specific features that they claim constitute this design defect. And it is fascinating to look at how they work in concert.
Let's trace how a user experiences these features, because they really act as a sequential funnel to pull you in.
Right. So you open the app, and the very first thing you encounter is feature 1, the infinite scroll.
The lack of a bottom.
Exactly. There is no bottom to the page. There is no stopping queue. I actually found a quote in the sources from Ezia Raskin. He's the actual developer who invented the infinite scroll.
What did he say?
It's incredibly haunting. He told the BBC, quote, "If you don't give your brain time to catch up with your impulses, you just keep scrolling."
Wow.
Right. It was designed specifically to eliminate the friction of decision-making. You never have to actively choose to see more. You just have to passively fail to stop.
And while you are scrolling, passively failing to stop, you are suddenly hit with feature 2.
Variable ratio notifications.
Exactly. These are the little red badges, the pings, the buzzes on your phone, but crucially, they are totally decoupled from a predictable schedule.
Right. You don't get a notification the exact second someone likes your post.
No, the algorithm actively holds them back. It bundles them and delivers them in unpredictable clusters. And this is the exact operant conditioning mechanism used in slot machines.
The lever pull.
Yes. The unpredictability creates an intermittent reinforcement schedule. Behavioral psychologists have known for decades that this is the absolute most powerful way to instill compulsive behavior.
Because your brain is guessing.
Right. Your brain literally becomes addicted to the anticipation of the reward, not the reward itself.
Which leads right into feature 3. Algorithmic content escalation.
Right, keeping the stakes high.
Because once they have you hooked on the slot machine pull, they have to keep the content stimulating, right?
Of course.
So the algorithm monitors your micro behaviors and begins serving increasingly extreme, polarizing, or even emotionally distressing content, simply because that is what provokes a physiological response.
It has to escalate the stakes to prevent habituation. If you see the same level of content, you get bored.
Exactly. And then you have features designed to explicitly punish you for trying to leave, which is feature 4.
Right, targeting loss aversion. This is most visible through streak mechanics.
Snapchat is notorious for this.
Oh, heavily. Snapchat tracks the consecutive days you've messaged a specific friend, and it displays it right there as a number next to a little fire emoji.
And if you miss a single day, the streak dies.
And the thing is, for teenagers, this isn't just a silly game. It is a quantified metric of their social standing. The anxiety of losing a 500-day streak literally forces kids to log in when they are sick, when they are on a family vacation, or when they are just exhausted and need to sleep.
It penalizes disconnection.
Yes, heavily.
And if you're on a platform like YouTube or TikTok, you're constantly fighting feature 5, autoplay.
Which completely removes the agency of the user.
Right. You don't click next video. The system makes the choice for you before you even have a chance to put the phone down.
It just rolls right into the next hit of dopamine.
Exactly. And who is experiencing all this? That brings us to feature 6, age verification gaps.
This is a huge point of contention in the lawsuits.
Huge. They are hammering the tech companies for implementing purposefully weak age gates. Like a simple drop-down menu asking, "Are you 13?" That is not a security measure.
No, it's a liability waiver.
Exactly. They know millions of children are bypassing these screens, and it exposes developing brains to an environment that was fundamentally engineered for adults.
But the most insidious element, and the one that really ties all of these other features together, is feature 7.
Personalized emotional profiling.
Yes, and this goes so far beyond tracking what you simply like or share. The algorithms are analyzing how long you hover over an image down to the actual millisecond.
They track your micro-hesitations.
Exactly. And here's the dark part. If a teenager lingers on a post about eating disorders or self-harm or severe depression, the algorithm does not register that as a cry for help.
No.
It registers it as high engagement. It identifies a deep emotional vulnerability and relentlessly exploits it by flooding their feed with similar triggering content just to maximize screen time.
Okay, so just to make sure I am wrapping my head around this whole legal maneuver completely.
Sure.
Under the old Section 230 rules, holding a platform liable was essentially like trying to sue an apartment landlord because one of their tenants was shouting abuse in the hallway.
Right. The law says, hey, the landlord didn't say it, you can't sue them.
Exactly. But with this new design defect argument, the plaintiffs are effectively saying, listen, we don't care what the tenants are shouting.
The shouting isn't the point.
Right. We are suing the landlord because he built the hallways like an inescapable maze. He painted over all the exit signs. He installed strobe lights to disorient everyone. And he is pumping a chemical stimulant into the ventilation system to make sure nobody ever sleeps.
That is an incredibly vivid but legally accurate framing.
We aren't suing over the speech. We are suing over the hostile architecture of the building.
Exactly. You are attacking the environmental engineering itself. And legally, for this to actually succeed, the plaintiffs are relying on the standard of substantial factor in causation.
Okay, what does that actually mean in a courtroom? Like in practice?
It means the plaintiffs do not have to prove that Instagram is the singular, isolated cause of a 14-year-old's clinical depression.
Because that would be impossible.
Completely impossible. Human psychology is way too complex for that. But the law doesn't require that level of singularity. The law only requires a jury to find that the product's design was a substantial factor in bringing about the harm.
I see.
So if the platform's algorithm intensified a pre-existing vulnerability, or if it noticeably accelerated a downward mental health spiral in order to capture more ad revenue, that easily meets the threshold for liability.
But, here's the massive hurdle with product liability, right?
Okay.
If you are going to claim a company designed a defective product that harms people, you generally have to prove that they actually knew it was harmful.
Yep.
You have to prove intent, or at least gross negligence. Like you have to show that the engineers and the executives looked at the data, saw the damage occurring, and chose to push the product anyway.
Exactly. You need the smoking gun.
And that brings us to the discovery phase of this litigation.
Mm-hmm.
Because in January 2026, Judge Yvonne Gonzalez-Rogers ordered the unsealing of a massive trove of internal documents in MDL 3487.
The Oakland case.
Right. And reading through these exhibits, it's breathtaking.
It's shocking.
It is one thing to hypothesize that these companies prioritize engagement over safety. It is entirely another to read their own internal Slack channels and slide decks, confirming it in absolute clinical detail.
The documents that were unsealed by the Tech Oversight Project, they really strip away all the public relations messaging.
Entirely.
Let's look at how Meta quantified their user base. There is an internal slide deck from 2018 labeled Exhibit 71, conducting what they called a market landscape review.
Right.
In this document, they literally calculate the lifetime value of a 13-year-old teen. They assigned a specific cold monetary figure.
Roughly $270.
Yes. $270 per young teenager.
They put a literal price tag on a middle schooler's attention, $270.
And once you assign a financial value to a demographic like that, you build the infrastructure to acquire it.
Of course.
Exhibit 1179 is a document internally titled The School's Review, spelled with multiple O's. It outlines the specific objectives of their youth growth team. Their explicit, stated goal was to get younger teens onto Facebook and prevent them from leaving.
By any means necessary.
Right. They developed strategies to deeply infiltrate high schools.
This was the part of the reading that genuinely made me furious. The Instagram Ambassador Program from 2018.
Oh, the tastemakers.
Yes. The documents show Meta was actively recruiting teen tastemakers, literal kids, between the ages of 13 and 17. They were paying these minors with compensation and branded swag to act as, and this is their literal internal terminology, plugs at local high schools to drive adoption of the app among their peers.
It's basically a stealth marketing campaign.
And to top it all off, They made these children sign non-disclosure agreements.
Right. NDAs for minors.
They were running a covert NDA-protected marketing operation inside public high schools. It feels incredibly reminiscent of big tobacco paying college students to hand out free cigarettes on campus in the 1980s.
The parallels are really difficult to ignore. And the internal documents show they knew exactly what kind of friction they were facing in this demographic: parents.
Right, parents are the obstacle.
Exhibit 41 details a 2018 product pitch called Tweens on Facebook. The product team recognized the rising trend of Finstas.
Which are fake Instagram accounts.
Right, fake accounts that teens use specifically to hide their online behavior from their families. But instead of seeing this as a safety issue, the development team saw an opportunity.
Which is wild.
They actively proposed building a private mode directly into the app that would provide teens with, quote, plausible deniability.
They were engineering features specifically to help minors evade parental oversight.
Yep.
How does an executive sit in front of a congressional committee and talk about their robust parental controls when their own development teams are pitching plausible deniability features to 12-year-olds?
The contrast between the public testimony and the internal dialogue is just stark. It's night and day.
Absolutely.
But the most legally perilous documents are the internal assessments regarding mental health itself.
Right.
In an August 2019 presentation, Meta's own researchers reported back to management with a really blunt assessment. They wrote, quote, teens can't switch off from Instagram even if they want to.
They knew.
They documented that teens talk of Instagram in terms of an addict's narrative, spending too much time indulging in a compulsive behavior that they know is negative but feel powerless to resist.
And then there's the 2020 employee chat log.
Yeah.
You have one employee typing, "Oh my gosh, all IG is a drug," and another employee immediately replying, "We're basically pushers."
We're basically pushers. That phrase, captured forever on a corporate server, is something plaintiffs' attorneys literally dream about. But we have to be clear here, because the sources demonstrate this is not an isolated Meta issue.
No, it's the whole industry.
The entire industry is implicated. Let's look at Google and YouTube.
Right.
The unsealed documents include 2018 slides where Google openly acknowledges that their autoplay feature directly disrupts users' sleep patterns. They had a 2018 internal review of their G Suite for education products that bluntly stated YouTube isn't safe, often blocked in schools.
Yet another Google document from 2020 explicitly argues for highly aggressive strategies to onboard kids because, quote, capturing them early leads to brand trust and loyalty over their lifetime.
Exactly. The CEO of YouTube, Neil Mohan, was even compelled to give a deposition regarding these internal contradictions.
And we see the exact same patterns at Snap and TikTok. The filings reference internal emails from Snap CEO Evan Spiegel. He is literally shown reacting to internal data proving that middle schoolers were a rabid, almost exclusive user base of Snapchat.
He knew this was happening, despite Snap's strict public policy that users must be 13 or older.
And TikTok's documents might honestly be the most brazen of them all. They have a September 2021 internal memo admitting that compulsive usage on TikTok is rampant, and actively noting that their younger users have a profoundly limited capacity for self-regulation.
And don't forget the transcript from that working group.
Oh, the PTA one.
Yeah.
There's an unbelievable transcript from a working group that TikTok hosted with the National PTA and the Family Online Safety Institute. During a panel, 8 to 12-year-old children openly admitted in front of TikTok representatives that they routinely lied about their ages to access the platform.
So they know the age gates are failing. They know the usage is compulsive. They know the sleep disruption is real.
So put yourself in the shoes of the defense attorneys for a second.
Okay.
You walk into federal court tomorrow. The plaintiffs project a massive slide on a 20-foot screen showing a Meta employee calling themselves a pusher. How on earth do you defend that? Like, what is the legal argument when the internal reality is so devastatingly incongruous with the public relations narrative?
Well, it is an incredibly difficult needle to thread. But these companies have access to the best legal minds in the entire world, and they have constructed a very robust, multi-layered defense.
What's their angle?
First, they focus heavily on their mitigation efforts. They point to the fact that they have introduced thousands of engineering hours into safeguards.
Like the digital well-being tools.
Right. They highlight their parental supervision hubs, their sensitive content blurring, and their time management tools like those prompts that pop up after an hour suggesting the user take a break.
Right.
They argue that these features are empirical proof that they do not have malicious intent, but rather that they take youth safety very seriously.
Okay, but what about the employee chat logs? Like, we are pushers. How do you explain that away?
The defense argues that in any massive global corporation with tens of thousands of employees, you will always find informal, hyperbolic Slack messages.
Just employees venting.
Exactly. They argue that the plaintiffs are engaging in massive confirmation bias, basically cherry-picking a handful of informal, out-of-context chats from literally millions of pages of discovery to construct this malicious narrative that doesn't actually reflect the company's official policy or the consensus of their data science teams.
Interesting. And how do they tackle the medical data? How do they argue against the Surgeon General and the clinical data linking their algorithms to depression?
This is where they really lean into the inherent complexity of psychological science. They argue that adolescent mental health is deeply, intrinsically multifactorial.
Meaning there's a lot of things causing it.
Exactly. They bring in their own expert witnesses to testify that you simply cannot isolate the Instagram algorithm as the proximate cause of a teenager's anxiety.
So they point the finger at other stuff.
Yes. They point to the lingering effects of the COVID-19 pandemic lockdowns, massive academic pressures, shifting social dynamics, family instability, and just the general chaotic state of global news. They argue the plaintiffs are scapegoating technology for much broader societal failures.
Which, to be fair, is a compelling argument to a jury. It's hard to prove a direct one-to-one link in mental health.
Right.
And there's also a massive constitutional argument happening in the background too, right?
Yes, the First Amendment defense.
Right.
The tech companies are arguing that an algorithm, the actual code that decides what content to show you, is fundamentally a form of editorial discretion.
They're saying the algorithm is speech.
Exactly. It is protected speech. And therefore, if the government or the courts try to regulate how the algorithm works, they are directly violating the First Amendment rights of the corporation. They are fighting fiercely to maintain the position that code is speech.
So the battle lines are really drawn. We have the design defect theory, the unsealed smoking gun documents, and the tech industry's multifactorial First Amendment defense.
It's a clash of titans.
It really is.
Yeah.
So how is this actually colliding in the real world right now? Because we aren't just talking about tomorrow's trial. This litigation has been churning for months. What does the legal battlefield actually look like today, and what kind of financial damage are we talking about?
The scope is almost difficult to comprehend. We are witnessing a multi-front legal war that really rivals the big tobacco settlements of the late 90s or the recent opioid litigation.
Ain't that big?
It is. The center of gravity is the federal track MDL 34-7 in Oakland under Judge Gonzales Rogers. As of our latest data, there are over 3,137 individual personal injury cases pending there.
Over 3,000 families suing.
Exactly. But that is just the federal track. You also have a massive state track consolidated down in Los Angeles, JCCP 5255.
Right, I saw that in the notes.
That docket holds over 1,300 lawsuits filed not by individuals but by public school districts.
1,300 school districts.
Yes. And parallel to all of that, you have the attorneys general from 43 states pursuing their own consumer protection lawsuits against Meta and TikTok.
It is a siege. And the thing is, we don't have to guess how juries might react to this evidence, because we already have the outcomes of the bellwether cases.
Right. The initial trials used to test the legal theories.
Let's talk about the first blood drawn in this conflict. The KGMV Meta and YouTube case from March of this year, 2026.
The Kaylee case.
Yes, Kaylee. This was a 19-year-old girl who was put on the stand. Her story was deeply, deeply harrowing. The testimony showed she began using YouTube at age 6 and Instagram at age 9.
So young.
By her early teens, the algorithmic escalation we talked about earlier had dragged her into deeply toxic echo chambers. She developed severe depression and life-threatening eating disorders.
Just tragic.
Her legal team brought the design defect argument to a jury in Los Angeles. And the jury did not just side with her, they handed down a staggering $6 million verdict.
And we really need to dissect how that $6 million was structured, because the structure is a massive warning siren for the tech industry.
Break that down for us.
The jury awarded $3 million in compensatory damages, meaning money to cover her medical bills, therapy, and pain and suffering.
Standard stuff.
Right. But the other $3 million was awarded as punitive damages.
Why is that distinction so critical?
Because punitive damages are incredibly difficult to secure in court. They are not about making the victim whole. They are exclusively designed to punish the defendant for gross negligence, malice, or intentional misconduct.
Oh, wow.
By awarding punitive damages, the jury sent a crystal clear message. They looked at the internal documents, they listened to the executives, and they concluded that Meta and Google knew exactly how dangerous their products were and deliberately chose ad revenue over child safety.
That is a huge precedent.
And they also apportioned the blame 70% to Meta, 30% to Google, showing they actually understood the nuanced differences in how the different algorithms impacted her.
And if you are an executive at Meta, that punitive damage ruling has to keep you up at night. Because it's not just individual families winning, the institutional lawsuits are drawing blood too.
The school districts.
Right. Look at the Breathitt County School District case from May 2026. This isn't some wealthy suburban enclave. This is a rural, cash-strapped school district in Kentucky.
Right.
They sued the tech platforms, arguing that the apps were causing such severe behavioral disruptions, anxiety crises, and distraction in their classrooms that the district had to divert massive amounts of their limited budget to hire extra counselors and deal with property damage.
It's essentially an economic externality argument.
Exactly.
The tech companies make the profit, and the public school system bears the financial burden of managing the psychological fallout.
That's perfectly stated. And the tech companies didn't even let it get to a jury. Right before the trial was set to begin, they settled.
They paid up.
The Breathitt County District secured a reported $27 million settlement. Meta paid $9 million. Snap and TikTok kicked in about $8 million each, and YouTube paid $2 million. A single rural school district extracted $27 million.
Incredible.
And let's not forget state-level regulatory actions. Just a couple weeks ago, in early August 2026, a judge in New Mexico ordered a massive $567 million fine against Meta for egregious child safety and privacy violations.
When you synthesize these financial ramifications, a very grim picture emerges for the tech industry's liability exposure.
It looks bleak.
The tech companies, they argue these are disproportionate, absurd financial penalties. But you have to look at the mechanics of the mass tort industry. These massive plaintiffs' law firms operate on contingency fees, usually taking between 33% and 40% of any settlement or verdict.
So they're highly motivated.
Very. When they see that a single school district can yield a $27 million settlement, it acts as chum in the water. It highly incentivizes a sophisticated, heavily capitalized apparatus of trial lawyers to aggressively recruit more plaintiffs and file thousands of more cases.
The floodgates open.
Right. The Real Cost report we reviewed notes that with over 3,000 personal injury cases and 1,300 school districts already filed, the aggregate financial exposure is simply unprecedented.
But I want to push on the math here, because I was looking at these numbers, and something feels fundamentally broken.
Okay, what do you mean?
Go back to Exhibit 71 from the Meta documents. They calculated the lifetime value of a 13-year-old user at $270. That is the total ad revenue they expect to extract from that kid over their life.
Yes.
But if they are now paying out a $6 million verdict to one teenager and a $27 million settlement to one school district, the unit economics are totally inverted.
They're completely upside down.
Right. So is this legal wave an actual existential threat to Meta's stock and the engagement-based business model? Or, considering Meta is a multi-trillion-dollar company, is this just the cost of doing business? Like, is a $567 million fine just a very expensive parking ticket?
It's the defining question for the future of the industry, honestly. You are right that for a $1 trillion market cap company, a $6 million verdict is literally a rounding error.
They make that in minutes.
Exactly. Even a $500 million fine can be absorbed into quarterly earnings without causing a panic on Wall Street.
All right, they print money.
But the true existential threat isn't the immediate cash payout of these early cases. The existential threat is the precedent.
The legal precedent.
Yes. If the appellate courts consistently uphold the legal theory that the foundational architecture of the internet, the infinite scroll, the variable ratio algorithm is legally classified as a defective product, the courts won't just award money.
What will they do?
They will issue injunctions. They will legally mandate that these companies structurally alter how their applications function.
They will force them to turn off the casino.
Exactly. If an injunction forces Meta or TikTok to disable the very features that guarantee prolonged user engagement, their daily active user metrics will plummet. Time on app will collapse.
And their revenue tanks.
And because their entire advertising revenue model is predicated on maximizing time on app, the underlying foundation of their stock valuation would fracture. That is why they are fighting this with every resource they have. It's not about the $6 million. It's about defending the right to operate the engagement machine.
Which brings us to the reality on the ground. Because the courts are churning along, the bellwether cases are settling. But mass tort litigation takes years, sometimes a decade, to fully resolve.
It moves very slowly.
Parents, teachers, and families are dealing with the fallout of this crisis right this second. They can't wait for the Supreme Court to rule on algorithm design in 2030.
No, they need help now.
So how is society structurally fighting back in the interim?
We are seeing significant, highly aggressive action on the legislative front, particularly at the state level.
Say laws.
Yes. The most prominent example is California's SB 976, which is formally known as the Protecting Our Kids from Social Media Addiction Act.
I read the breakdown of this bill in the sources. It is incredibly direct.
It is. Signed into law in 2024, it completely abandons the old strategy of just asking platforms to do better. It directly attacks the design mechanisms.
How so?
The law strictly prohibits platforms from providing what it legally defines as addictive feeds to minors without verifiable explicit parental consent.
Oh, wow. So you have to opt into the algorithm.
Exactly. It also structurally restricts platforms from sending push notifications to minors during known sleep hours, so between midnight and 6 a.m. and during standard school hours. It is an attempt to legally mandate friction back into the system.
But the tech lobby has been fighting this tooth and nail.
Brutally.
Because the Wikipedia source compiling the history of SB 976, it reads like a legal tennis match. The tech lobbying group, NetChoice, sued almost immediately. Then a federal judge temporarily enjoined, meaning paused crucial parts of the law in early 2025.
Right.
Then the state appealed, and the Ninth Circuit Court of Appeals largely affirmed the law in September 2025, allowing the state to actually move forward with enforcement.
A big win for California.
But then, in November 2025, Meta, Google, and TikTok file a countersuit, dragging it right back into court, leaning heavily on that First Amendment argument we talked about, that regulating their feed violates their right to free speech. It is just constant, exhausting legal whiplash.
It is a total war of attrition. And while the policy battles rage in the appellate courts, individual families are left trying to manage the fallout in their own living rooms.
Right.
But the sources we reviewed highlight a very harsh truth about our current approach to parenting in the digital age.
What's that?
What we have been doing is failing.
You're talking about the focus on education.
Yes. There is this prevailing societal myth of digital literacy. It's the idea that if we just sit our teenagers down and educate them, if we teach them how algorithms work, how variable rewards function, how their data is harvested, they will use that knowledge to make rational, healthy choices and just put the phone down.
But the data says that's completely useless.
Completely. The Spencer Law Firm's analysis cites a wealth of data, including studies from psychological science, demonstrating that conscious awareness of persuasive design does absolutely nothing to stop the biological pull of the dopamine loop.
It doesn't work.
The reward circuits in the brain operate entirely below the threshold of conscious, rational deliberation, which honestly makes total sense when you think about it. Telling a 14-year-old to just put the phone down because they intellectually understand how an algorithm manipulates them is like telling someone to simply not be hungry because they understand the chemical composition of a fast food burger.
Exactly.
You can know exactly how the burger is engineered to taste good, but that knowledge doesn't turn off your biological hunger response. It's fighting a deeply ingrained physiological urge with an informational pamphlet. You are bringing a textbook to a chemical gunfight.
That is an excellent way to conceptualize it. Willpower is a finite resource, and it's absolutely no match for an engineering team backed by limitless compute power.
So true.
So if education and willpower fail, what actually works? Based on the medical, legal, and behavioral sources, families must pivot from relying on discipline to implementing structural environments.
The sources outline a very clear, actionable, 5-step framework for this.
Yes, let's go through
I
it.
really want to highlight this because this is the practical takeaway for the listener. Step 1 is baseline audit.
Crucial step. The data shows an immense perception gap. If you ask a parent to estimate their child's daily screen time, they will confidently say, oh, about 2 hours. But when you actually pull the device data, the reality is almost always closer to 5 or 6 hours.
The numbers don't lie.
Exactly. You cannot manage what you do not measure. You have to start by auditing the actual screen time data on the device to completely shatter the illusion of control.
Once you have the reality, step 2 is establishing unyielding physical structural barriers, not rules, barriers.
It's a difference.
Device chargers must be permanently moved out of the bedroom. Phones do not come to the dinner table. You have to physically architect the home environment to reduce access without requiring a constant, exhausting verbal negotiation every single night.
because the negotiation wears you down.
Exactly.
Step 3 is one I hadn't even considered until I read the legal briefings, but it is vital for medical or potential legal reasons.
Yeah.
You have to document behavioral patterns in writing.
Right, keep a log.
If you notice your teenager's anxiety spiking immediately after app usage, or if you are dealing with severe sleep disruption, do not just make a mental note. Write down the dates, the durations, and the specific behavioral changes. If you ever need to involve medical professionals or seek an IEP at school, you need a documented paper trail, not just anecdotes.
Which leads directly into step 4, involve pediatricians. The Surgeon General's advisory is actively urging the medical community to step up here.
They need to be on the front lines.
Doctors must incorporate routine, formal screenings for problematic social media use into their standard checkups, treating it with the exact same gravity as they treat physical health metrics like blood pressure or BMI. Parents should proactively ask their pediatricians for formal behavioral health screenings.
And finally, step 5, which honestly feels incredibly empowering. Request your child's platform data.
Oh, this is a game changer.
Under various privacy laws, the major tech companies are legally required to let you download the file containing all the data they hold on your account. Reviewing this massive file allows parents to see exactly how the algorithm has secretly profiled their child.
You can see the invisible tags.
Yes, you can see what emotional vulnerabilities the system has identified and what specific categories of content it is forcefully pushing into their feed. It instantly shifts the dynamic. It stops being a moral argument about wasting time and becomes a stark confrontation with a structural, engineered reality.
It pulls back the curtain on the casino.
It really does. So let's pull all of this together and synthesize the incredible journey we've been on for the last hour. We have tracked a massive societal paradigm shift today.
A total reframing.
We have moved from a culture that predominantly blamed parents for bad discipline and kids for a lack of willpower to unearthing a deliberate, multi-billion-dollar engineering architecture explicitly designed to hijack the developing human brain.
And we have the receipts to prove it.
Right. And for the first time in the history of the internet, the legal system, armed with thousands of lawsuits and damning internal corporate confessions, is treating this code not as a protected free speech issue, but as a defective, incredibly dangerous product.
The framing has permanently shifted from personal responsibility to corporate liability.
Right.
And the multi-state trial that begins tomorrow in federal court is merely the opening salvo.
Just the beginning.
What we are watching is the beginning of a decade-defining legal, cultural, and financial war over the absolute boundaries of digital engineering.
The stakes literally could not be higher for the future of how we interact with technology. So as we wrap up, I want to leave you with a final lingering question to chew on as you go about the rest of your day.
It's a big one.
It is. If the plaintiffs are successful, if the highest courts in the country ultimately decide that the core mechanic of the modern internet, the engagement-driven variable reward infinite scrolling algorithm, is legally classified as a defective and dangerous product that must be dismantled, how do we rebuild the digital world?
What comes next?
Exactly. If you effectively outlaw the dopamine loop that has driven trillion-dollar valuations for the last 15 years, what does the internet of tomorrow actually look like?
It is a profound, incredibly challenging question about the future of human connection and commerce.
It really is. I don't know the answer, but I know we are going to find out soon. So the next time you find yourself sitting in the dark, telling yourself just 5 more minutes, and an hour mysteriously disappears, remember the invisible architecture working relentlessly behind the glass. Thanks for taking this deep dive with us.